everyone, this is Advocate Anla Jayprakash. Welcome to Legal Desk. Today I am going to discussing about maintenance under the BNSS. This is one of the most important social justice provisions in the new criminal law. Even though the procedural law has changed, the heart of maintenance law remains the same. To ensure that no person who has a legal right to be supported is left to suffer because of neglect, abandonment, or breakdown of relationship. Earlier, maintenance was governed by Section 125 of the Code of Criminal Procedure. Today, that very same protection continues under Section 144 of the BNSS. The change in law has not taken away any rights. It has only carried them forward in a modernized framework. The objective remains clear: prevent destitution, protect dignity, and provide immediate relief to those who cannot maintain themselves. This provision applies to wives, divorced wives, children, and parents. It is secular in nature, meaning it applies to all communities irrespective of religion. It recognizes that responsibility does not disappear merely because relationships change or break down. Whether it is a marriage that has failed, a child who is dependent, or parents who are unable to support themselves, the law ensures continuity of care. Proceedings under Section 144 of BNSS are summary in nature. They are designed to be quick and effective, not technical or time consuming. The magistrate is not expected to conduct a full trial. The focus is on immediate needs, not long-term adjudication. Interim maintenance can be granted even at the early stage because hunger, shelter, and medical needs cannot wait for years of litigation. Another important aspect of maintenance under BNSS is that it recognizes reality. Court understand that financial control often lies with one party. Therefore, strict proof of income is not insisted upon at the initial stage. Instead, court look at lifestyle, standard of living, and apparent earning capacity to ensure fairness. Maintenance under BNSS is not charity. It is a legal obligation flowing from responsibility. It is not a punishment. It is a protective measure rooted in constitutional value of equality and dignity. The law ensures that no person entitled to maintenance is forced into helplessness simply because a case is pending. In simple words, maintenance under the BNS represents the law's commitment to human justice. It bridges the gap between legal process and human survival, reminding us that justice is not only about final judgment but also about how people live while waiting for them. Under Section 144 of BNSS, the law clearly identifies who can approach the magistrate seeking maintenance. The first and most common category is a wife. A legally wedded wife who is unable to maintain herself can file maintenance petition if her husband, despite having sufficient means, neglects or refuses to maintain her. The right exists irrespective of religion because Section 144 is a secular provision. The law also recognizes that marriage may break down, but responsibility does not automatically end. Therefore, even a divorced wife can claim maintenance petition under Section 144 of BNSS as long as she has not remarried and is unable to maintain herself. Once a divorced woman remarries, the liability of the former husband ceases under this provision. Children form the next important category. Minor children, whether legitimate or illegitimate, have an absolute right to maintenance from their father under Section 144 of BNSS. The law does not discriminate between sons and daughters or between children born within marriage and outside marriage. The duty to maintain flows from fatherhood, not from marital status. Section 144 also extends protection to children who have attained majority but are unable to maintain themselves due to physical or mental abnormality or injury. In such cases, even though the child is an adult by age, the law treats inability as the deciding factor and allows maintenance to be claimed. Parents are another important class recognized under Section 144 of BNSS. If a father or mother is unable to maintain himself or herself, they can file a maintenance petition against their son or daughter. This reflects the social responsibility embedded in the law. The obligation is not limited to sons alone. Daughters are equally responsible if they have sufficient means. It is important to understand that Section 144 does not require the claimant to prove cruelty, adultery or fault. The only questions the magistrate examines are whether the claimant is unable to maintain himself or herself and whether the respondent has sufficient means but is neglecting or refusing to maintain. The proceedings is summary in nature, intended to provide quick relief. Another important aspect is that the petition can be filed at a place convenient to the claimant. The wife, child or parent can file the petition where they reside, where the respondent resides, or where the parties last resided together. This ensures access to justice and prevents harassment through distance. In simple words, Section 144 of the BNSS protects your categories of persons: wife, divorced wife, children and parents, provided they are unable to maintain themselves. It places a legal duty on those who have sufficient means to support their dependents and prevents abandonment in the name of legal technicalities. The purpose of Section 144 is not punishment. It is a social justice. It ensures that no person with a legal right to be maintained is left to be begged or suffer while legal proceedings continue. When a husband abandons his wife, the first feeling most women experience is confusion mixed with fear. There is emotional pain, social pressure, and above all, uncertainty about survival. Many women believe that unless there is physical violence or a divorce case, they cannot approach the court. This belief is completely wrong. Indian law, especially Section 144 of BNSS, provides a direct, effective remedy for exactly this situation. The maintenance petition begins with a simple narration of facts. The wife explains the marriage, the period of cohabitation, and the fact that husband has left her or driven her out and stopped maintaining her. She must clearly state that she has no sufficient independent income to maintain herself. At the same time, she must state that husband has sufficient means but has failed to provide support. This is the heart of Section 144 petition. Along with the main petition, the wife can also seek interim maintenance. This is crucial in abandonment cases. The court has the power to grant interim maintenance even at the initial stage because abandonment creates immediate hardship. If the situation is urgent, the court can pass an interim order without waiting for prolonged contest. After the petition is filed, the magistrate issues notice to the husband. He is given an opportunity to respond and explain why he is not maintaining his wife. If he claims that the wife is earning or she left voluntarily, the burden is on him to place material before the court. The law does not accept bare allegations as defense. The proceedings under Section 144 of BNSS are summary and speedy. The magistrate does not conduct a full trial like a civil case. The focus is on survival and responsibility. If the court is satisfied that the wife has been abandoned and is unable to maintain herself, it will pass a maintenance order directing the husband to pay monthly amount. The husband disobeys the maintenance order, the law provides enforcement mechanism. The wife can approach the same court for recovery of arrears. The court can issue coercive steps to ensure compliance. Maintenance order under Section 144 of BNSS are not symbolic, they are enforceable by law. It is also important to understand that filing a maintenance case does not require the wife to file a case for divorce. Even if the marriage legally subsists, abandonment itself is sufficient ground to seek maintenance. The law does not expect a wife to dissolve the marriage in order to survive. In a simple term, if a husband has abandoned his wife, Section 144 of the BNSS gives her a direct legal pathway to claim maintenance. She does not have to suffer silently and she does not have to wait for years. The law stands with her the moment neglect begins. Today I am concluding here. In tomorrow's video, I will explain the remaining aspects of maintenance in detail. Thank you for watching.